Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can you go to jail at a preliminary hearing? This is a critical question for anyone navigating the criminal justice system, and the answer is yes, you absolutely can, but it's crucial to understand how and why, because it's not for the reason most people think. A preliminary hearing isn't a trial. Its sole purpose is for a judge to listen to some of the prosecutor's evidence and decide if there is enough probable cause to believe a crime was committed and that you committed it. If the judge finds probable cause, your case moves forward toward trial. You are not found guilty or innocent at this stage, so you cannot be sentenced to jail for the crime itself. However, there are several ways you can end up in a jail cell right after this hearing. The most common reason is related to your bail. If you were previously released on bail, the judge can decide to change the conditions of your release. During the hearing, the prosecutor might present evidence that makes you look like a flight risk or a danger to the community. Maybe you were arrested for something new while out on bail, or maybe a witness testified that you tried to intimidate them. If the judge hears this, they can revoke your bail entirely or set it so high that you can't afford it. In either case, you'll be taken into custody and held in jail until your trial. Another way to land in jail is by being held in contempt of court. This has nothing to do with the charges against you and everything to do with your behavior in the courtroom. If you are disrespectful to the judge, yell, cause a disruption, or refuse to follow a court order, the judge can find you in contempt and immediately order you to be jailed for a short period as a punishment. Finally, while less common, it's possible that information revealed during the hearing could lead the prosecutor to file new, more serious charges against you, which would almost certainly impact your bail status and could result in you being taken into custody. So, while you won't be sentenced for the main crime, the preliminary hearing is a high-stakes event where your freedom is very much on the line. Your actions and the evidence presented can directly lead to a judge deciding you need to await your trial from behind bars. It highlights why having an experienced attorney by your side during this critical stage is absolutely essential. They can argue against the prosecutor's evidence and fight to keep you out of custody. Thank you for watching this breakdown. If this information was helpful, please give this video a thumbs up and consider subscribing to the channel for more straightforward explanations of the legal system. Remember, this is for educational purposes only and is not a substitute for legal advice from a qualified attorney.